Hello everyone and welcome back to your channel Lawpedia. In this particular video, we'll be understanding Maintenance and Welfare of Parents and Senior Citizens Act 2007. So the very first question that may arise over here is why the act was formulated. The act was formulated to provide for a more effective provision for maintenance and welfare of parents and senior citizens that has been guaranteed and recognized under the Indian Constitution. The Act extends to the whole of India and it applies also to citizens of India outside India. So this particular Act was actually enacted to grant a holistic protection to the senior citizens of our society, which at that particular point of time was observed wasn't there. So from moving to a joint family system to a nuclear family setup, the overall society observed that a lot of senior citizens were being deserted by their own children. So this act grants protection, security to the senior citizens of our society. Moving forward, the act has certain basic definitions that we must understand in order to understand the act itself. The act defines parents to mean father or mother, whether biological, adoptive, or stepfather or stepmother, as the case may be, whether or not the father or mother is a senior citizen. So the act includes biological as well as adoptive or stepfather or stepmother in the ambit. Now the term children, wherever it is used in the act, includes son, daughter, grandson and granddaughter, but does not include a minor. So now we'll be dealing with this particular aspect, that why minor is not being included, and this is in fact being driven to be included in the definition of children by the amendment which is proposed to be done to this particular act. Now, maintenance according to the act would include provision for food, clothing, residence, medical attendance and treatment. So the term maintenance, wherever it is being used in the act, would include provision of these aspects to our senior citizens. Next, senior citizen according to the act and the definition provided in the act would mean any person being a citizen of India who has attained the age of 60 years or above. So this is the age bracket that is being provided for the definition of senior citizen. Moving forward, now the core provision of the act is section 4 of the act, which deals with maintenance of parents and senior citizens. So the section 4 of the act reads as a senior citizen including parent who is unable to maintain himself from his own earning or out of a property owned by him shall be entitled to make an application under section 5 in case of. So understanding the first aspect. Now the first aspect here basically explains that a senior citizen including a parent who is unable to maintain himself. So the person is unable to maintain himself from two sources, either from his own income or out of a property owned by him, then that particular person can make an application under section 5. In case of first, grandparent or parent against one or more of his children not being a minor, in case the person is a childless senior citizen against such of his relative referred to in clause 2G of section 2. If you see clause G of section 2 of the act, it basically means any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. So basically, if the senior citizen does not have his or her own child, such person can be made applicable or can be made to maintain that particular senior citizen who would inherit the property after the death of that senior citizen. So I hope you understood the basic core section 4 of the act. Moving forward in understanding the other interesting aspects. Any person being a relative of a senior citizen and having sufficient means shall maintain such senior citizen provided he is in possession of the property of such senior citizen or he would inherit the property of such senior citizen. And if there are more than one particular relative, such relative enjoying the property of the senior citizen, then the maintenance shall be in proportion in which they would inherit the property. Now, the other aspect is the obligation of the children to maintain his or her parent extends to the needs of such parent, either father or mother, or both as the case may be, so that such parent may lead a normal life. So now this aspect describes the obligation of the children. Now the core provision which deals with application for maintenance and which is a very important provision is section 5. Now section 5 states that an application for maintenance under section 4 can be made by who all? First, it can be made by a senior citizen or a parent. Second, if he is incapable by any person or organization authorized by him. Now, when I'm saying organization over here, I mean a voluntary association registered under the Societies Registration Act. Thirdly, the tribunal may take suo motu cognizance as well. So there are three scenarios of making an application under section 5. Now, the section 5 also provides that when such an application is made and a case is pending before the tribunal can also order for interim maintenance for the provision of the senior citizen. And very important that such an application for interim maintenance, if made, has to be disposed of within a period of 90 days from the date of service of notice. Quickly moving forward, the next aspect is the application once made, what happens then? So in case an application has been duly made under section 5, what happens next is a notice of the application is given to the children or the relative against whom the application is made. So let's say a person A makes an application against his child B. So the B will be given notice of the application. B will be given an opportunity of being heard, and then there will be an inquiry held for determining the amount of maintenance. Now, next very important factor that you all must be aware about is if children or relative so ordered. So if once the tribunal orders the person to pay maintenance and the person fails without sufficient cause to comply with such an order, any such tribunal may for every breach of the order issue a warrant for levying an amount due in the manner provided for levying fines, and may sentence such a person for whole or any part of each month's allowance for the maintenance and expenses of proceeding, as the case may be, remaining unpaid after execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made, whichever is earlier. Quickly moving it forward and understanding other aspect, section 6 of the act basically deals with jurisdictional aspect and the procedure. So where the application can be made. So section 6 basically states that the proceedings under section 5 may be taken up against any children or relative in any district. Point number A, where he resides or last resided, or point number B, where children or relative resides. So there are two aspects, either where he resides or last resided or where the children or relative resides. Next aspect is on the receipt of the application under section 5, the tribunal shall issue process of procuring the presence of children or relative against whom the application is filed. And for securing such attendance of children or relative, the tribunal shall have the power of judicial magistrate of first class as provided under the Code of Criminal Procedure 1973. Moving forward, we'll be understanding deciding the case ex parte, that means without the other party. Now, when does this happen? So, if tribunal is satisfied that the children or relative against whom an order for payment of maintenance is proposed to be made is willfully avoiding the service or willfully neglecting to attend the tribunal may proceed to hear and determine the case ex parte. So in case there is non-cooperation, the tribunal can very well decide the case ex parte. Moving forward, Next interesting question comes over here is very important aspect, that is scope of conciliation. Now where does conciliation come into picture? Now the Act very interestingly provides that the tribunal, before hearing an application under section 5, may refer the same to a conciliation officer, and such conciliation officer shall submit his findings within 1 month, and if amicable settlement has been arrived at, the tribunal shall pass an order to that effect. So very interesting, the Act has a scope and has an ambit of conciliation as well while considering the application under section 5. Moving forward, we'll be understanding deposit of maintenance amount. So now how does that happen? So the maintenance tribunals may be constituted by states to decide on the monthly maintenance amount payable to senior citizens by children and relatives. The amount according to the Act shall not exceed rupees 10,000 per month. So if you read section 7 of the Act, it talks about constitution of maintenance tribunal. Now what does that say? The state government shall, within a period of 6 months from the date of the commencement of this Act, shall constitute for each subdivision 1 or more tribunals, and these tribunals are responsible for deciding the case in case of this particular Act. And the tribunal shall be presided over by an officer not below the rank of subdivisional officer of a state. So the children and relatives must pay maintenance amount within 30 days. Important aspect, that they should pay the amount within a period of 30 days of the order of the tribunal. Moving forward, now this is a very interesting aspect that the Act deals with, is section 23, which talks about transfer of property to be void in certain circumstances. What is this? Now often in some instances we see the senior citizens have transferred the property to their children. When does that become void? Where any senior citizen who, after the commencement of this Act, very important term, has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the transferor's said property shall be deemed to have been made by fraud or coercion or under undue influence, and shall be, at the option of the transferor, be declared void by the tribunal. Understanding it within a help of an example. Let's say there is a person or a senior citizen named A who transferred his property to B, one of his children, entire property, on the terms and conditions that B would pay, let's say, rupees 1,000 per month to A. However, after some time, B stopped paying this particular maintenance amount, and therefore the basic necessities of A weren't being satisfied by B despite the transfer of a property by A in B's name. Now as soon as this happens, and if A makes an application in the tribunal, such a transfer can be declared void because it was made subject to B maintaining A. Therefore, if B fails to pay the amount, the transfer would be declared void. Moving forward in understanding another very recent, very important aspect, that is the Maintenance and Welfare of Parents and Senior Citizens Amendment Bill 2019. Now this particular bill aims to revolutionize the Act to a certain aspect and brings in certain important and core aspects which weren't being addressed by the earlier Act. Firstly, the bill brings stepchildren, adoptive children, children-in-law, and legal guardians of minor children under the definition of children. Now what does that mean? If you will see, according to the Amendment Bill 2019, in the definition of children, stepchildren and adoptive children have been included, as well as children-in-law have been included. Relatives, in the ambit of relatives, minor has been included along with the guardian. In the definition of parents, grandparents and parents-in-law have also been included. Secondly, under the Act, We have already understood maintenance tribunals may direct children to pay a maximum maintenance of rupees 10,000. However, the bill removes this particular upper limit on the maintenance fee. Now, the bill also provides that if the children or relative fail to comply with maintenance orders, the tribunal may issue a warrant to levy the due amount. Failure to pay such fine may lead to imprisonment up to 1 month or until the payment is made. So now this is also one of the core provisions of the bill, that if you don't pay the amount or the maintenance levied by the maintenance tribunal. Now the question comes, we are saying that don't pay 10,000 rupees but pay according to the your assessment. How will the tribunal assess this? The bill states that the maintenance amount will be calculated on the basis of A, the standard of living and earnings of the parent or senior citizens. So let's say if you're providing a maintenance to a particular senior citizens, you need to assess their living standard, and B, the earning of the children. So the administrative officers, the concern is here, they may not have the judicial expertise required to determine the maintenance amount payable. So moving quickly forward to the next interesting aspect is certain other amendments being brought by the bill. So the first aspect is abandonment of senior citizen or parent. So if a person abandons the senior citizen or parent, according to the current act, such a person is punishable with imprisonment up to 3 months or with fine up to 5,000 or both. So now this is a current provision. What happens as of now? The amendment being proposed is this particular factor, that the bill seeks to punish such a person with imprisonment between 3 to 6 months. Now increasing the punishment, and secondly increasing the fine, which is now proposed to be up to rupees 10,000 or both. So now this is the scope and ambit of increasing the punishment for in cases of abandonment of senior citizens. Secondly, the bill adds very important aspect to the act is the abuse of senior citizen. So the bill proposes to add, in such a case, punishment may be given to the person with imprisonment between 3 to 6 months and fine of rupees 10,000 or both in case a senior citizen is abused. And we often hear a lot of instances of abuse of senior citizens constantly being happening in homes right now. So therefore, this particular amendment becomes even more important in the background of the current scenario. Moving forward and understanding the last aspect, legal practitioners may not represent the parties before the tribunal or in the tribunal aspect. The Act states that no party to a proceeding before tribunal or the appellate tribunal. So the Act has two aspects. First is the tribunal, and the appellate tribunal have also been constituted just in case the person wants to appeal against the orders passed by the tribunal. Can be representative. So in such a case, the person cannot be represented by a legal practitioner. So while this particular restriction on legal representation may expedite the process, why is it? It's of course to make the process a lot faster and reduce the expenses for parties involved. So this is the core idea behind having such a provision that legal practitioners may not represent the parties in the tribunal. It contradicts, very interestingly, Section 30 of the Advocates Act 1961, which states that all advocates have right to practice in all courts, including Supreme Court, before any tribunal or person legally authorized to take evidence, and before any other authority or person before whom such advocate is entitled to practice. I hope with this, when I end the video, we understand the core concepts of the Act of the 2007 Act. What all provisions are there, how the maintenance application is made, what is the jurisdiction, what is the maintenance tribunal, how you can go to the appellate tribunal, what are the core provisions of the Act itself, and what are the amendments that have been proposed to be brought by the 2019 Amendment Bill. And that's it for today's video. I hope you did like it. Please let me know in the comment section below if you have any doubts, and please stay home, stay safe, and keep learning.